So first, this obviously is um, a space to provide an update on what's happening with the detransitioner lawsuits in the U.S. and also kind of an help uh, help gain understanding about the significance of these lawsuits, the theories, the legal theories behind them, because they're not, all straightforward med mal lawsuits. So discussion about theories, standards of care, how the insurance companies come into play, what the implications are regarding wins and losses. We're also going to bring on some of our detransitioner guests um, after our update. So we have a great discussion plan. Thank you all for being here. And let's start with Kathleen Dooley, who's going to give us an update and an overview.
Okay, thank you. And thank you, everybody, and good evening. Thank you, everyone, for being here. Yes, I'm just going to provide an overview of the detransitioner lawsuits that we are aware of as of today. We are aware that 11 lawsuits have been filed in this country. All but one are in state courts, and one is in federal court in Massachusetts. For those who are interested, because it may be in your state, I will tell you where these lawsuits have been filed. There have been 3 in California, 1 in Wisconsin, 2 in Rhode Island, 1 in Massachusetts, 1 in Nebraska, 1 in Texas, 1 in North Carolina, and 1 in Oregon. As to the claims that are being asserted, on first blush, one might view these cases as medical malpractice cases, but the fact is that these are not cookie cutter lawsuits. Each one of them comes at it from a different legal standpoint and very fact specific, in fact. The claims, in addition to medical mal, and again, med mal is not in every lawsuit, involve claims of fraud and misrepresentation. And those claims involve, what was presented to the patients and what they weren't told, and the promises that were made about how the treatments would improve their lives. There's also civil conspiracy to commit fraud, lack of informed consent, negligent infliction of emotional distress, intentional infliction of emotional distress, violation of consumer protection laws, unfair and deceptive trade practices. Many states have statutes that relate to unfair and deceptive trade practices, breach of fiduciary duty, which I thought was an interesting one, and violation, and this is a very interesting one also, violation of Section 1557 of the Affordable Care Act's non-discrimination provisions, anti-discrimination on basis of sexual identity. So some might say the simplest way of framing that is they transed away the gay. We have 7 lawsuits involving minors who were transitioned or began transitioning. We also have 2 lawsuits of individuals who transitioned in their early 20s, one in the mid 20s and one at age 30. The lawsuits involve 9 females and 2 males. All of these lawsuits allege in great detail some psychological comorbidities that accompanied the dysphoria that each of the plaintiffs experienced. And these comorbidities involve, and they're not limited to, history of trauma, sexual abuse, physical abuse, substance abuse, schizophrenia, ADHD, PTSD, bipolar disorder, severe depression, anxiety, borderline personality disorder, internalized homophobia, eating disorders, autism, self-harm, dissociative identity disorder, obsessive compulsive disorder, and polycystic ovary syndrome, just to name a few. Their current physical mental states, as alleged in the complaint, consist of a plethora of conditions such as osteoporosis, brain fog, mental distress, vaginal atrophy, possible sterility, Hashimoto's disease, which is an autoimmune disease requiring lifelong medication, compromised bone structure, chronic pain in joints, pelvis, bones, spine, possible infertility, hot flashes, neurological and psychological damage, schizophrenia, severe pain and disfigurement of shoulders and neck due to testosterone, phantom breast syndrome, stunted puberty, physical, social, neurological, and psychological damage. So, who is being sued? Um, I think one of the most interesting defendants is the American Academy of Pediatrics, and that's being sued for publishing what the lawsuit refers to as the fraudulent 2018 policy statement on affirmative care, which was drafted by Dr. Jason Rafferty, who was still a medical resident at the time he drafted it. Also, Dr. Michelle Forcier is also being sued. Forcier was featured. If any of you out there had watched Matt Walsh's "What Is a Woman" movie, Forcier was figured in that one and was famous for saying, "Does a chicken have a gender identity? Does a chicken cry? Does it commit suicide?" The other defendants involve doctors, hospital systems, social workers, and anybody involved in the care and treatment of these individuals. Now, the funding mechanisms vary. Just so you understand, these lawsuits require a lot of money to get liftoff. It could be anywhere from $70,000 to $100,000, and maybe even more, because many states, especially when you have medical malpractice allegations, require the plaintiff to attach an affidavit from an expert in the particular area of medical malpractice. And those experts are very, very expensive, and these affidavits have to be very carefully drafted because they must be unassailable. These experts are going to eventually be deposed and testify, and so their words have to be precise and concise, and they have to be very careful in their choice of words and how they frame the malpractice. We believe that while some firms are funded to handle these cases, others probably take out loans, but there is also a tax-exempt nonprofit organization, and in full disclosure, I'm on the board of directors of it, called the ThemisResourceFund.org. What we do is we connect detransition plaintiffs with attorneys and help them fund the lawsuits for their injuries. So people donate to us to help us achieve that goal. And there's also an investment firm called Vallecito Capital. It's a mission-driven investment fund that seeks to ensure righteous lawsuits never falter for lack of financial resources. And they're at vallecitocapital.com. Now, how any of these lawsuits will turn out is anybody's guess, and understand that lawsuits in the United States are rarely resolved in a year or two. These things grow legs. They involve many technical matters such as motions to dismiss or discovery motions. Each of these lawsuits depends on their facts, the law, and the willingness of the bench to listen to these cases. And I'll also add that what we are seeing is the defendants who are being sued appear to be well funded with access to top-notch law firms who will fight to the death to defeat these lawsuits. And in addition, many of the defendants have medical, where there is a medical malpractice claim alleged, or where the claims fall within the definition of medical incident as it's defined in the medical malpractice insurance policies. They may also have, funding as well. So these are not easy cases, and so in the fullness of time, we will eventually see how they turn out. Thank you.
Okay, that gives us an update and an overview of what's happening. And thank you, Kathleen. I neglected to say that Kathleen's from on the board of Themis, which thank you for letting people know what Themis is doing, the important work they're doing. Since we have some folks here from, let's see, we have from Detrans Help, we have Camille here. Camille, do you want to speak briefly about the lawsuits that we have in the U.S.?
Perfect. Thank you so much. So, yeah, so pretty much for the lawsuits, what we're seeing is that we have organizations like Transition Justice, and we have Transition Justice, and we have Themis, and we have, I feel like that's pretty covered. So, um, we do have a lawsuit tracker on our website. I know there are some other lawsuit trackers that are cropping up, but it's been good to be able to track these. And then I know personally on our website we have a couple from outside the United States, but those are a little bit more difficult to keep up to date. So.
And do you want to plug your lawsuit? What's the URL for that? I mean, not your lawsuit, your website, your URL.
Yes, so my website, or the website for Detrans Help, is www.detranshelp.org.
Okay, great. Thank you. Thank you for joining us, and thank you to our other detransitioners in the audience. We'll promote you to speaker after the discussion with our speakers and get your commentary. Here to give some insight into the lawsuits, we have two attorneys, Kevin Kelly and Mitra Forahar. I'm not sure I'm pronouncing it right. Why don't you to unmute yourself, and let's start with a discussion on the theories, some of the theories that Kathleen Dooley mentioned, the approaches for these different lawsuits.
Sure. This is Kevin Keller. I have been a litigator for about 30 years, and I've been on both sides of the cases as a defense lawyer and as a plaintiff's lawyer, and have done a good bit of medical malpractice as well. And so, to help flesh out some of the descriptions of the medical malpractice action you've described, basically for any tort, any lawsuit, for money, you need 4 elements. I'm not going to do a law school class, but just as real quick thing here to flesh out everything: duty, breach, causation, and damages. And one of the large defenses that is going to be used, of course, by the medical industry in the U.S. is that they have not breached a duty, because the standard of care, they're going to argue, the standard of care is that you can go ahead and give puberty blockers to 8-year-olds, according to these professional organizations, right? Professional societies. You whether it's endocrinologists or psychiatric associations, pediatric associations, you all probably know they've been pretty aggressive on pushing and allowing for this type of care to occur. So puberty blockers starting at 8 a lot of times, and I know people shake their heads at that, but it's like that's untrue, but it's true, because that's when puberty begins for a lot of people. It can begin younger for girls, and that's been pushing younger and younger, right? So puberty blockers can begin then. Cross-sex hormones are administered. That's all part of basically permissible standard of care that's allowed, and that's what will be argued and already has been argued in the defense of these cases. The problem with, and then of course they cite WPATH as well, and SOC 7, which has allows for a lot of this type of thing to occur as well. And even the Department of Health and Human Services and Rachel Levine have put out, a lot of statements and a chart. A lot of you have probably already seen. If you haven't, you can go online to HHS right now and look up their guidance for this type of care, and it's right there printed. So what the doctors are going to say and the hospital systems are going to say is, "Oh, see, we've met the standard of care." The problem with that is, A, you can have an incorrect standard of care. That's the first, the first prong of the attack is you can have an incorrect standard of care. Of course, the U.S. has had them, especially targeting women for years and years, whether it's lobotomies, overrectomies, overuse of hysterectomies, mother's little helper, benzos. These have all very disproportionately targeted females and young females in particular. And it's just the medical. There's a lot of articles written about it. Cutting the body to cure the mind is one of them, and it's a fallacious standard of care that they're using that's really promulgated as more of a political activism, and that is what is going to be argued against that as well. The second attack on it would be, well, you're not these hospitals that are operating on 12-year-old girls to do double mastectomies. And I know people are saying that doesn't happen, but I think there was just documented 70 of them at one hospital, right, in Oakland. 2019, I think. The stats always have a large delay on the collection data, right? But that's one hospital. So these hospital systems deny doing it, but we know that it's happening because we're gathering the statistics. But the main argument, rushing forward a little bit there, is, well, you're not even following your own standards, because even if you look at WPATH standards, right, or psychiatric association standards or endocrinologist standards, they all have in there that you have to take into account all the circumstances. You have to treat most conservatively, or that you should treat most conservatively first, right? And they're not doing that. They're not doing what would call a full differential diagnosis, where you eliminate other causes of the psychological issues that are arising, and you treat those first. You can call it watchful waiting, but instead, what many of them are doing on one or two visits or no visits are jumping straight to administering the puberty blockers, or straight to, or very quickly at least, to cross-sex hormones, and then later to the surgery. So, that's the major explanation of what's going on in these lawsuits as far as medical malpractice concerns go. It's a lot more discussion to talk about the other causes of action that are being raised as well, but most states do not allow you to kind of end run and get around the medical malpractice causes of action if you're suing a healthcare professional. And so it's very difficult, as was being pointed out earlier, to bring those type of lawsuits. And I would point out that the numerical number, the monetary number thrown out there of it can cost $100,000, that is I can tell you as a lawyer, that's a very conservative number. Experts can easily cost $200,000 in a case, and then the attorney's time can be easily several $100,000, or more. It's not unusual in a complicated lawsuit to have $500,000 to $1 million worth of attorney's fees, and $200,000 to $300,000 worth of expert fees. So litigation is very expensive, and all this is going to take a lot of time, obviously. And my I'm not going to call her my co-counsel, but the other lawyer in the case, who's also active. What do you think?
Hi, this is Mitra. I agree with your comments and your analysis. I think the alternative causes of action can be challenging without any precedent. So I think one question is whether there is a precedent in a comparable context that the lawyers can rely on. And the rules of admission of evidence, which can be different between federal courts and state courts, may make a difference as well. The statute of limitations can make a difference. There are just there are so many variables that it makes it very difficult to really predict the outcome. And at this time, we don't have any case that has gone all the way through the legal process, so we have no precedent for how any judge in any jurisdiction would rule on these cases. So we are in a very uncertain position in terms of knowing where this goes. On the other hand, I think that all the cases make really good, solid legal arguments, and there is good evidence of wrongdoing. So we have to have some faith in the legal system that will bring together the challenges as well as the facts that support the case to arrive at a reasonable outcome.
Okay, it would be really helpful when if we would get kind of a detailed discussion of each of those different approaches that the lawsuits are taking. Let's save the med mal for last because that's obviously we'll want to talk more about the specifics of med mal suits and why it's so complicated. But in terms of discrimination, and fraud, what are what are the theories? How does that translate into these lawsuits?
I'll speak a little bit about the discrimination issue, and I think Kevin can speak to the fraud one if you don't mind, Kevin. Um, I think with respect to discrimination, it very much depends on what the records indicate, what the medical record indicates. To show that there was discrimination in provision of health care or in the medical judgment, you have to make a case that there was a protected characteristic that was relevant to the treatment, and that protected characteristic was disregarded. So that's just the basic rule. But this may vary, again, among the circuits. This is a federal case, and it may be that different circuits would have a different interpretation or a different way of applying it, or set out different elements to be satisfied, because the Supreme Court has not specifically spoken to this.
And
Yes.
which characteristics are we looking at in these particular cases?
Well, generally speaking, protected characteristics are race, age, sex, sexual orientation, like a recognized disability potentially could form basis of a discrimination claim. Potentially. So these are, again, we are all in new territory. These are new cases. These are cases of first impression. But I would look to those classes, to those particular classes.
Okay, and then do we want to talk about the Kevin?
Yeah,
You
I'll
talk
talk.
about the
Sure, I
fraud.
can talk about the fraud a little bit. So some of the lawsuits have fraud claims as well. This is a claim that's separate tort, separate count, separate cause of action that's listed in the complaint. The one that you mentioned that was filed by the Jordan Campbell firm in Rhode Island against the American Academy of Pediatrics and Dr. Rafferty, who you mentioned, and Forcier, who you mentioned, several other doctors here. It's one of the counts in that lawsuit. But any fraud lawsuit is basically that you're suing because somebody did a material misrepresentation of fact to you that caused injuries to you, or the misrepresentation of a material fact. So in this case, if you're familiar with the history of the studies and what representations have been being made to these individuals that I would say have been victimized, but maybe that's too strong of a word for some people, that have been operated on or given puberty blockers or cross-sex hormones that have changed their body for life. The material misrepresentations are that the studies support this type of care, right? So there have been 7 main reviews now by countries or jurisdictions, and none of them have found support for the contention that you're saving, somebody's life, that you're preventing a potential suicide by not allowing this person to transition, right? So that's one of the major weapons that shows up in almost all of these lawsuits, is that the doctor, of course, tells the parents, would you rather have a live son or a dead daughter, or vice versa? And it even gets more graphic than that. And the point on these lawsuits is, look, if you're a professional you're not somebody off the street, right? You're held to a higher standard of care. You're supposed to know the quality of the studies, the quality of the data, not 30 or 50 people from a Dutch study in 2011 when half of them didn't even come back to follow up or whatever. It's what have the actual statistics shown such that I'm giving that type of advice to somebody, right? And it's false. It is an unsupported bases that people are making a decision on. Now, that's just one example, right, of the supposed to have a more positive effect on suicidality, when actually the most relevant study we know now says it's about 20 times the opposite direction at least post transition. So, but also um, that it can't be treated in a more conservative nature, in a more conservative manner first, that you shouldn't, wait a year or two, or you shouldn't undergo this type of therapy first, watchful waiting. Statistics are misrepresented. For example, it's now pretty well known, right, that if you just had watchful waiting, if you just allowed and gave support and caring support for the child, almost all of them, the vast majority, would desist or would not want to go forward with medicalized intervention, right? Whereas if you do begin the process, I mean, it's almost a slam dunk. It's 95% in most studies. It runs from 87, some of them are 100, some of them are 95. They're looking at the numbers, cohort studies, that they will go on to have medicalized care. Are these things told to the parents, right? Just take these couple stats we just ran over. Is that being told to the parents and the families? Is that being told to the child who almost always has significant and severe comorbidities, right? That affects their psychological care. And then a lot of these people at the same time are on psychotropic meds that are affecting their very ability to think, the maturity of their brain. I mean, you're giving advice to a child that you put on puberty blockers that has ceased the development of their brain from being bathed in the hormone of their natal sex for perhaps years, and then you're not even giving them, in many cases, the full picture and the full repercussions and what would happen if you didn't have the surgery and what would happen if you did. So that's the basis for the fraud claims. The problem is a lot of jurisdictions will not allow a fraud claim to go forward if it is against a medical care provider, or at least it's a very difficult legal argument, right? Because the medical malpractice statutes and case law in that jurisdiction is supposed to cover the medical malpractice action, any alleged negligence of a medical care provider. So it can be a very difficult uphill battle. Some jurisdictions it's more easy in, some it's a lot more difficult in. But those are the type of kind of novel legal theories that are being tested and explored, because this is a novel and unique fact pattern we have, right? It's really hard to compare it to another wave of medical malpractice or tort that's out there. So there's going to be some tough law and some tough decisions that need to be made if the wrong is to be fully addressed by the justice system, including looking at statute limitations, damage limitations. These are damage caps that exist on medical malpractice suits that cap the amount of damages you get. Most jurisdictions have pretty severe limiting damage caps that won't allow you to get over a certain amount, or won't allow you to get punitive damages, for example. So those are all difficulties that are going to be wrestled with over the course of this litigation, and we've just kind of seen the beginning of it, just seeing the first wave of these cases.
Kathleen, do you want to weigh in on this?
I do. I think Kevin raises an excellent point, and it it goes to um, the fact that in the wake of the WPATH files that were released on March 4th by Michael Schellenberger and Mia Hughes, when you look at those files, you see that the physicians discussing their patients don't call them patients, they call them clients. And that raises the notion that perhaps this is not medical um, focused treatment, that it's more consumerism. And so when you look at the claims that allege violation of consumer protection laws and unfair and deceptive trade practices, these are consumer driven, consumer focused statutes and claims. And so if a court decides, you know what, this is not just strictly medical malpractice because I do see consumerism here. And then when you tack on to that the breach of fiduciary duty, that basically the fiduciary duty is the legal responsibility to act solely in the best interest of another party. And fiduciary, it means trust. And so a person with a fiduciary duty has a legal obligation to maintain that trust. For example, lawyers have a fiduciary duty to act in the best interest of their clients. And how does one allege and ultimately prove that claim? Well, um, if typically it involves transacting business with another corporation. But I think what I think what where these claims are headed is these physicians and these hospital systems and practices personally profited from their transactions. I think it's a difficult claim, but again, I think if we go back to the WPATH files showing that nobody's discussing quote unquote patients, they're discussing clients, and that to me it takes it outside the physician-patient relationship and makes it a consumer transaction. I don't know. Do you have any thoughts on that, Kevin?
Yeah, I mean, I think it's interesting. I think what you're getting at is these are novel facts, right? Where you're going from a patient to a consumer, and the law should adjust to that. So, for example, not to get too esoteric, but in what kids learn in law school is there was a definition of theft, right, in or let's say early England, medieval Europe, where you could not take a good from somebody, that was not intended to be in your possession. So what happened is shippers would ship stuff by coach or carriers, common carriers, because they had the goods lawfully in their possession. Let's say a carriage or a ship would just take the stuff, would just take the goods because there was no crime committed, because the goods were legally in their possession. So then they developed what we now know as bailment law, right? Well, you still can't take the bailment that's in your possession. Then all sorts of laws come up for that, including when you go to a parking garage now, you get this little parking ticket. The parking garage, it's a bailment. They have your car there legally, or your garage does, if you take your car to a garage to get fixed. And laws develop around that to try to address that new and novel facts and situation. And I think that is what is going on here, where statute of limitations need to be addressed, right, in a different way than they have been under normal medical care. Because that's not what we're seeing. We're not seeing normal medical care. We're really seeing a form of activism and consumerism. And these consumer statutes that you're talking, these consumer protection statutes, um, trade, fair trade statutes, most of them are fairly punitive in nature. They benefit the plaintiff, the claimant. They have treble damages. A lot of them do, not each state, but Virginia, for example, treble damages, attorney's fees, right? I mean, Mitra has similar stuff under the American Disabilities Act. There can be attorney's fees. And I think there can be, I don't know if there's treble damages or not there. Mitra can address that, but there's, I'm not a constitutional tort person, expert at all. But I do think that's a good point. I think these are new facts. And look, there's another thing that happens out there, and that is if you bring a bunch of these lawsuits and they get your blood boiling because of the injustice that's done when the judges apply the law that they should apply, then what happens is the legislatures change the law, right? I mean, that's happened many times over the course, including for chemical torts, right? Asbestos cases, for example, food poisoning cases. All of them have had statutes changed to address and allow lawsuits, give longer statute of limitations, stuff like that, to correct injustices that are addressing that kind of new factual scenario that's out there. So I absolutely agree.
Kevin, can you also, for those who aren't familiar with statute of limitations, what the typical statute is for medical mal, can you just sort of give everybody a thumbnail sketch of how that works?
Sure. So a statute of limitations, for example, if you're in a car accident and you're claiming personal injury, let's take it as most simple quickly, then let's say your jurisdiction has most of them are 2 years, some of them are 3 years, 2 years to bring the lawsuit from the date of your accident, right? And that's true for medical malpractice actions. From the date of the wrong committed that caused the harm to you, and boy, do we get in some complicated issues there, because who knows when the harm manifests in this type of case, right? Let's say you become sterile as a young teenage girl, and you don't know that you cannot get pregnant until you're 30 years old, and lo and behold, you cannot get pregnant because you took a course of T, right? And in many instances, especially after a course of puberty blockers, it only takes one course of testosterone to make that happen. It's amazing. So you don't know, can't figure it out for 10, 15 years. And so your statute of limitations is passed. That means you are barred from bringing a cause of action. You cannot bring the lawsuit. Now, if you do it, if the wrong occurs to you as a minor, then you have, let's say it's a 2-year statute of limitations, then you have 2 years from the time you reach majority. So you might have till you're 20 years old. Whereas, as we know, the mind doesn't mature, and a lot of people don't desist who have gone through a gender confusion, gender dysphoria, until they're, let's say, 25. It's an average of 5 to 7 years. It's not 1 or 2 years is the average time arc there. Now there's studies out there. Just check behind me and read them. New studies come out every day. But so that presents specific difficulties. And even within the medical malpractice statute of limitations, there's something called a statute of repose. We don't have that in a lot of states, but I believe it's New York. Yeah, New York has a statute of repose. Let's say you have medical malpractice committed on you when you're 12 years old. It might have a statute of limitations of 2 or 3 years, but then it has an additional statute of repose that in no event after 5 years after let's say the bad surgery, in no event after 5 years can you bring a cause of action. So that person might be barred for bringing a cause of action, really even before they reach majority, even before they reach 18. So these are statutes that are in place to stop. They're tort reform statutes, right? They're supposed to protect the medical doctors from being sued too much and driving medical insurance costs up. Nobody's saying these are evil tort reforms. I'm just saying they only awkwardly apply and unfairly apply when we start just looking at a couple of instances that I've raised, right, of how they work in reality in a case of somebody who has had gender-affirming care that's gone wrong or that they regret.
So, you raised this point about the insurance companies and the increase in cost to them. I don't know if, Mitra, we've talked about this a little bit about how the insurance companies come into play around this, whether or not, this kind of belief that's out there is really valid. If we see a win, will that change insurance, malpractice insurance? If we see more suits getting filed, what does that landscape look like?
Okay. I'd like to step back a little bit into the statute of limitations and then move on to the insurance issue. I think some states do have discovery rules. I haven't done a survey to see which ones have it and which ones don't, but I think that can be helpful with respect to Detrans lawsuits. Also, to the extent a person has been treated at a federally funded clinic where the lawsuit can be brought under federal rules and a federal statute of limitations applies. Also, the discovery rule kicks in because the federal statutes are subject to the discovery rule. So people should not despair or give up if they are more than 2 or 3 years out. It's not obviously a favorable situation to be in many states, but it is very much fact dependent on the person.
Yeah. If I could jump in, I know I'm not supposed to go mic off yet, but Mitra's absolutely correct. It's just how long could I talk about statute of limitations? There's also in addition to the discovery rule, right, which a lot of jurisdictions have. There's the and I know Mitra, we consulted on a case that was similar to this. You've got the course of care and treatment rules in a lot of states, right? That if you're with the same medical care provider for several years, let's say, then it might toll or extend the statute of limitations by several years because you could be kind of caught up with that medical care provider, and then it might be 2 years, for example, after you leave that person's care. Now, there's a lot of tests in case law on both of these exceptions that Mitra and I just talked about. So they're very fact specific, but certainly do not be if you feel wronged and harmed, do not be dissuaded from seeking legal counsel. Some of the very good lawyers that are already out there that are on these lawsuits that we've mentioned, Chuck Lamondre in California, and the Jordan guys in Jordan Campbell firm in Texas are doing great work on it. Mitra does as well. So please do not hesitate to seek counsel.
Right. Yeah, I think it's important to explain that we are really talking in a very general sense about what the rules are, just to familiarize a lay audience with the general legal concepts that are relevant. But please do not take anything from this conversation and apply it to a specific situation, because the law is full of exceptions and it's very much fact dependent. So it's best to take specific legal advice for the situation.
Hey, we lawyers, we forgot to mention that we're not providing legal advice here.
Right.
Right. Absolutely. None of it is fact specific. It's all just trying to lay out kind of, what the difficulties are and what the lay of the land is, and not to make, cast specific aspersions against any specific defendant or give specific legal advice, which is why you need to follow up with any of us or any of the people we've mentioned. So, yeah. And I think you wanted to talk about insurance next. I don't know if Mitra, you wanted to get started with that. You were going to return to that.
I'll get it started, and you can pick it up. Just insurance companies, will basically, they will pay, and if they raise the insurance fees on the physicians or on the hospital, then it might raise a question for the doctors or the hospital as to whether this is worth it. But these procedures are very expensive, so it may still be worth it if these cases are successful. So we would have to have cases that are very, very successful, like very, very large judgments that would impact the insurance coverage. If people think that is how this is all going to stop, I think it's not the most realistic picture, in my opinion, that insurance companies will somehow play a role in stopping this. I think if that comes to pass, that point is very far away right now.
Well, I agree. It's very far away. The hope is that the practice becomes so risky for practitioners that it drives the medical malpractice rates up. So it will help dissuade what we think is an unfair and medical procedure that's being foisted on people. So if lawsuits start coming, then the underwriters and the number crunchers at the insurance companies have to determine what the premium bases are, and it could have an effect of dissuading this type of practice. Unfortunately, the industry is so profitable that I mean, it was zero in 2007, right? Essentially zero. What, one clinic, arguably two in North America, right? It's a 2 billion industry today, 2 billion plus. Is projected to be 5 billion by the year 2030, at least by one publication study online that studies financial markets. So it's going to take a lot, but this is the beginning of things, right? This is the first wave of litigation. There could be, and I'm not commenting on one way or another, but as far as making a judgment of what would be successful, right? But there could be big pharma litigation. God knows there's been a lot of it in the past, right? There's been a lot of billions and billions recovered from the opioid industry, sorry. A crisis with the states and the attorneys general, I never get that right, jumping on board and bringing lawsuits. And, it takes a while for the bricks to start falling. You got to rock the Coke machine a while if you're going to try to tip it over, but you got to start somewhere. And these initial lawsuits and these really brave people that are bringing these victims that are bringing these lawsuits, they should be applauded. They are at the beginning of things. The trail is not paved for them yet, right? The path is not easy yet.
Right. Yeah, we need more detransitioner lawsuits if
Absolutely.
we think that this is the way to counter this movement. We need many, many more. I mean, even if all the lawsuits that are outstanding right now are successful, 10 or 11, 12 lawsuits, a handful of lawsuits is not going to stop anything.
No, it's going to take hundreds, and then I think hundreds can turn into class actions. But that's the way a lot of mass torts or pattern litigation has begun.
Isn't
right?
isn't that the way the opioids and the DES lawsuits back in the 70s and the asbestos lawsuits in the 70s and 80s?
Yeah,
There's a trend,
and
it's a
they were
long game.
trends. Yeah, it's
a long game.
They lost the initial waves of those lawsuits, those asbestos lawsuits, lost. Right, there was a lot of losing going on before the winning began, and then lo and behold, it even transformed the insurance coverage industry because they had to figure what manufacturers were making asbestos or held the asbestos company for one fractional second. If there was some mergers and flips going on, that could be sued and trigger insurance policies. So, money is what, unfortunately, I hate to talk about it like that, but money is what will bring this down because money is a large motivator for what is driving it.
Right, and the insurance companies, in the wake of the asbestos lawsuits, started imposing exclusions, right? For environmental contamination or whatever. I mean, and that's
for environmental, certainly.
Yeah, we're starting to see little bits and pieces of medical malpractice insurance thing. I think there was some clinic in the Midwest or something. All of a sudden, when they brought a new doctor on board, the premiums went through the roof. And so I think it takes time. You've got these actuaries in the insurance companies that are sitting back and saying, let's just see how this is going to go. And I think it's just a matter of time before they decide, okay, if we're going to cover it, here's your premium, and it's going up.
Well, talking about the pharmaceutical industry and some hits that occurred out there, some settlements and verdicts. AbbVie for its off-label use of a testosterone product, Androgel. If you remember those lawsuits, they settled for, oh my gosh, I don't even know how many hundreds of millions. Right? It was huge settlements for off-label use. Sound familiar? Of this product, and even Lupron, the main puberty blocker. There's several, but the main puberty blocker had a tainted history as well. It suffered. They settled Lupron. The manufacturer settled criminal and civil charges for $875 million. That'll get somebody's attention. Conspiracy for it was involved in manipulating Medicare programs, Medicaid programs, I'm not speaking to the veracity of it, but the settlement certainly occurred for that much money. And Lupron has been the subject of a lot of controversy for civil rights, for administering them to, um, uh, basically criminals or convicts, inmates as a chemical castration drug if they were sexual predators, sexual offenders. And so, the industry, lawyers were standing up for the rights of the, pedophiles and sex offenders, not that they don't have rights, in the administration of Lupron and here we are again with it being used on, young ladies to cease their puberty. So,
So can I jump in here a question about that? So, I think the kind of the uneducated, I would say, opinion is that somehow these pharmaceutical companies are protected because um, they're not promoting these uses for these drugs. It's the clinicians that are promoting it, and the drug manufacturers are saying, "Hey, we don't tell them how to use this stuff. We're just putting this out there." I mean, are they protected because of that kind of
very,
stance?
Well, the
very,
off-label use, right?
yeah,
The
it's an
off-label
off-label
use.
use, very complicated. So the the main defense that one of the main defenses that a pharmaceutical company would use, let's say in other case, I don't want to get too specific, is that to this case, to a specific case, because I don't have enough facts, but would be that if it's an off-label use, then the pharmaceutical company does not on its label instruct doctors and patients, right, of the limitations of how it's going to be used, right? So it's a defense for a pharmaceutical company to say, look, this is an off-label use. We're not recommending it for this use. We're not promoting it for this use. The FDA prohibits us from promoting it for this use. We're not allowed to advertise it, promote it. Now, what's happened in these other cases is they got caught with their hand in the cookie jar a few times. They actually were promoting them in different ways. If you know about the opioid industry, they were heavily promoting those salespeople going, into different areas of the country, not too far from Virginia, and in Western Virginia, Appalachia, and heavily pushing them. But they have refused to do the testing necessary to get on-label use, right? To get approval from the FDA for the specific treatment of gender dysphoria. It costs millions of dollars. It takes years to do it, but why would they do it? They don't have to do it, and they
Well,
have an additional defense.
there's a citizen petition, FDA citizen petition that was filed in September of 2023. I think it's still open for public comment, calling for the systematic review of off-label prescription of puberty blockers to children. And it's received literally hundreds of public comments that are saying, FDA, you need to take a look at this. And
Yeah.
so we're still, and the FDA's done nothing. They did a pro forma response, and here we are in March.
Yeah, it's
You know,
typically,
6
of
months
course,
later.
it's typically the pharmaceutical company that seeks the review, right? Because it's seeking a new use of their product. But I don't know the in and outs administratively, right, and regulations. I assume the FDA can force them if it's going to be used at all for an off-label purpose. Look, a lot of medications are used for off-label purpose. I mean, probably half the people in this phone call are taking meds for all. If you take a Benadryl tonight to help you go to sleep after this talk, that's an off-label use, right? Benadryl just happens to make you sleepy, in addition to helping with the allergies that occur this time of year. So it's off-label use is not necessarily an evil thing, but in its application in this case, there can't be any question that these companies, and it's not just Lupron, right? Or they're different main characters in the UK, main providers in the UK are heavily profiting from the use of these products, of especially Lupron and T definitely, but especially Lupron. Especially puberty blockers, right? Because they're being handed out like candy at a lot of places. I mean, that's what the reviews have said, right? That's what Tavistock said. That's what the reviews of the clinics in the U.S. that are advertising. You come in on your first visit and you can get puberty blockers. I mean, it's been crazy. Hopefully, that's being curtailed now. It looks like the turn of the tide has begun, but there's a long way to go.
Well, actually, I hate to be duly downer here, but there's a
Uh-oh.
nonprofit called Research Institute for Gender Therapeutics, RIGT, that was formed with the express purpose of securing FDA approval for drugs that are currently used off-label in so-called gender-affirming care. And according to this RIGT website, they are actively pursuing FDA approval of testosterone as a masculizing agent and estradiol as a feminizing. And then they're also um, seeking permission to just go ahead with Lupron for children. And we're seeing some disturbing news out of the FDA that they might consider Lupron for kids. So anybody who doesn't know about this, please Google RIGT. RIGT. I'm trying to find the website here. It's backed by Big Pharma. It's RIGT.org. And then you'll see they've got a pipeline and FDA process that they're aggressively pursuing. So
Well, again, there's a lot
I
of money
think you can.
involved, right? So should
Oh,
we be
you're not
surprised?
kidding. So I
Yeah.
think you can anticipate that the FDA petition calling for the systematic review is probably going to get another look by the people who first submitted it.
Um, Seems like it's relevant to talk about the WPATH files and whether or not those will have any impact on the current round of lawsuits or on future lawsuits, or how these larger clinics will and the medical associations will market themselves.
It's been less than a month, right? I'm interested in seeing the ripple effect. You have these lawsuits that have been filed, especially with the bans across the country, where everybody, the opponents of the bans are saying, we follow WPATH, we follow WPATH. Well, now let's take a look at WPATH. Let's take a look at those files. And how do people look at that? I don't know. I think they've kind of discredited themselves, but I'll welcome any other input on that.
I think WPATH is losing some of its shine with some of the more recent disclosures as being a credible purveyor of the standard of care, even though they out of one side of the mouth they say they don't provide the standard of care, and on the other side they do because they don't want to get sued. So, but yeah, no, I think there's a broader point here too. If I can just, and then I'll be quiet because I've been talking too much, and that is a lot that's going to help bring this industry down, and is not just the lawsuit, but it's going to be whistleblowers. People have to come out of the woodwork that work at these clinics, that work at these medical systems, large, huge medical. I mean, Kaiser's the one who's being sued in California. Have to come out and say, "Look, I've seen the emails back and forth. I've seen the texts. I've seen the communications. There's coordination here. There's promotion. There's, between." Well, I won't even say between, but between different players. Let's say it that way. And they have to be encouraged, and that is, I know there are hotlines out there. I think is it PEC? I forget the name of their website though. Has a website hotline for people to call in if they have concerns and to potentially gather whistleblowers. I should have a better plug for it, but I'm sorry, I don't have it on the tip of my tongue. But yeah, I think that's going to be a huge deal, and more and more is going to come out on WPATH. I don't know how in the world WPATH positioned itself to be someone establishing standard of care. I mean, you don't have to be a doctor or a medical care provider or anything to be a member of it. It's quite plainly a ideological organization that has a very strong certain angle to it. And if you read these complaints, that have been drafted by like Lamondre and like Jordan Campbell. They have very good sections on that, going through why they are ideologues. And then they make the additional point that even if WPATH and SOC 7 is not the standard of care, even if it is the appropriate standard of care, these medical systems aren't even following those very minimal and somewhat offensive safeties that are built into SOC 7, which are laughable. But they're not even following those, right? They're just kicking it out there. They're just giving the care regardless. So, in any event,
How how important for these cases is a standard of care? I mean, this is a new field. You've got the this supposed standard of care from this largely activist organization. Uh, how does that affect these lawsuits?
it's the first line of defense for for any lawyer defending the doctor or the medical care provider, the healthcare system facility, is we met the standard of care. Here is the standard of care. Here it is, right? Here's what this pediatric society says. Here's what the endocrinologists say. Here's what WPATH says. Even though they are obviously not evidence-based, which is amazing, this is the standard of care, and we're following them. Judge, it might change. Standard of care might change in 5 years. Maybe the plaintiffs are right. Maybe it'll change. But at the time my defendant, my client, performed this surgery or gave this advice or prescribed this medication or wrote the prescription for the medication, at that time, this was the standard of care. We're doing the best we can. We're doing the best we could. That's going to be the defense.
Okay, we want to get to listener questions and comments. So, is there anything that each of you wants to give us as a wrap up, or anything we didn't touch on that we should have in this brief hour? Mitra, let's start with you.
No, I don't have anything to add.
Okay, Kevin, have we missed anything crucial?
I think I've talked too much. I would just also say that, man, I hate social media, TikTok, and I know we haven't gone into rapid onset gender dysphoria and the influence of TikTok and other social media, but it is huge, huge. So the hashtag ampersand trans on TikTok has been viewed 26 billion times.
Yeah, it's a little grim. Kathleen, anything? And then I do have one more question for the group. But Kathleen, anything that we missed?
No, actually, and I've got a cold today, so I'm sorry if I sound a little nasally. No, thank you, and I really appreciate you giving us the opportunity to do this, Lauren. Thank you.
Okay, and then the last thing is, I think a lot of us want retribution, right? We want to see these clinicians held to account for what they've done to children and vulnerable adults, to our women's rights. What is the likelihood that, if we're just talking about these detransitioner cases, that clinicians will actually be held to account for the care, and I use that very ironically or sarcastically, the care they provided? Anybody? Kevin, let's ask you. Can you jump in on that?
Sure. Sorry, I was trying to lay back a little bit. Well, they're going to have insurance coverage for most of whatever's going to happen to them, right? So they're going to have medical malpractice insurance coverage. There's other types of coverage, commercial general liability coverage that covers other things such as, it can cover fraud, or at least not intentional fraud. It can cover negligent infliction of emotional distress as opposed to intentional infliction of emotional distress. Those are other torts that would take a while to explain. But I think what would happen is they would suffer more in the eyes of their peers, right? that these people are viewed as leaders of gender care at whatever, you know, I shouldn't mention specific hospitals. So, but there are some very major medical systems and hospitals that are um, very lenient with this stuff and are advertising it as if, hey, you come in and hysterectomies for our right to correct gender dysphoria for anybody 0 to 18, was just removed from one of the websites a few months back. So it's crazy what's being pushed out there, and I think it's going to be a loss of reputation, that this is not a valid approach, and that they've been selling a false product, and that eventually they're going to lose the status and the heads of their department and the surgical teams, and the care should be would cost so much to underwrite, to pay insurance coverage for, that maybe some medical systems will steer away from it. But it's going to take years to do that. One other thing that I think you've tried to ask a couple different ways, I can just spend 30 seconds on. If some of these torts that are not medical malpractice, like intentional acts, fraud, for example, intentional fraud, conspiracy, stuff like that, that may not have insurance coverage, because typically there is not insurance coverage for intentional acts, right? You can't go out and punch somebody and say, oh, I got insurance coverage for that. So typically that's an exclusion in most policies, most insurance policies. And so once you start getting verdicts against physicians that aren't covered by insurance, and they've got to pay out of pocket, that's going to have a huge influence.
I agree. I think right now, the definition of medical incident in many of these medical malpractice policies is so broad, okay, that medical malpractice insurance companies are going to start to look at these claims, even if it's 11 right now, and they're going to say, oh, we're going to have exclusions just with the commercial general liability, right? Kevin, the CGL policies said, okay, pollution out, mold. Remember the mold in the early 2000s and the fungus? Everybody was claiming they had toxic mold in their homes.
Black
All
mold.
of a sudden, everybody had a mold exclusion on their home insurance or a CGL. I think that's the next thing. I think medical malpractice policies are going to exclude claims for fraud, breach of fiduciary duty, all these intentional torts, violation of consumer protection laws. Because really, when you go to the gravamen of a complaint, it's alleging stuff that arises out of the medical treatment of the patient. And so I think there's going to be arguments on both sides, why it's covered, why it's not covered. And insurance companies are pretty good at responding to that.
Money's certainly going to drive everything, but as Mitras pointed out a couple of times, it's going to take a while, right? As you know, because we got 11 lawsuits now. I mean, I think there's going to be hundreds.
It's a long game. It's like the opioid crisis, which took almost 3 decades to come to a head with the class actions filed by states. This is a long game, everybody. It's a long game. And so these lawsuits will take time. And also, I wonder if any of the young men and women who are here, who have been through this medical issue, are you talking to any other folks who have been through this, who are, I know of young people who won't file lawsuits because their parents consented, and their parents have tremendous grief about doing that, and they don't want them to file the lawsuits. They're dissuading them from filing lawsuits. And the kids who are no longer kids, I mean, they're in the 20s now, are saying, okay, I can't do it because my mom or my dad feels bad, and I don't want to make them feel bad. But frankly, the parents were defrauded as well, So I wonder if anybody here that's been through this has any commentary on that.
Why don't we, maybe we should open it up to our audience and see if people want to speak. I want to thank our our speakers for joining on this. We knew it was going to be a fascinating and important discussion, and I hope everybody's kind of gotten a little bit better perspective on these lawsuits. And please, if you're interested in asking questions, please request to speak.
Well, there's some good
Um,
comments too. If you haven't had a chance to look at those, there's 11, and there's
Okay,
there's a
we'll take a
there's
look.
a few good checks there as well. I mean,
Okay, let's maybe go to those first. If any of the three of you want to address those.
well, I would just say one
comments.
of Leslie here agreed. Once a few big jury awards are achieved, more detransitioners will be able to take litigation seriously, and malpractice lawyers will be willing to take the cases. I think that's true too. There's not a lot of plaintiffs lawyers taking or considering or assessing. There's a handful. You know, Mitra and I and a couple of other law firms, a few other law firms have mentioned. And but once there's a saying, you know, once the ox falls, a million knives flash, right? the they'll jump on board. I think one of the reasons, though, if I can add 1 second of commentary here on this, that the American Bar Association, or whatever they've changed their name to this week, is not jumping on board the American Trial Lawyers Association, all the plaintiffs' lawyers on this, is because most of them are very I don't want to offend anybody, but they're very left. They're very anti-tort reform. They're very in league with the left, not with the right. So I think a lot of them are afraid to not afraid but it's not something they're going to jump on initially, right? Because it shouldn't be viewed as a right-left issue, but it is at this point in time. So I think that'll change as well. There's mention about Kaiser. Somebody said that there's 2 lawsuits in federal court. Julie Goldstein said Hannah Eulery and Shapeshifter, right? Julie Carlin. I think there's 2 in federal court. There's one that alleges violation of a federal statute.
Yeah, I want to thank Julie for straightening me out because I was not privy to the removal of the case from the Eulery case from Rhode Island, Bristol County Superior Court to the federal court. So thank you, Julie. I appreciate that.
So that's a diversity removal, right? That's not a subject law. It's not. In other words, there's not federal tort law that's being applied. Go ahead.
I'm assuming it is because I haven't seen the full complaint, but Julie just sent me a beautiful snapshot of the fact that it's been removed. So I'm assuming it's on diversity. Yeah.
We accept any and all corrections. Right. So
absolutely.
Can you translate what you just said for those of us who aren't attorneys? What does it mean, removed? What's the difference between the federal, like what's the significance of them being federal cases?
Sure. So when you're in state court, if you have something called diversity of citizenship, which is the plaintiff and the defendant are in 2 different jurisdictions. So I believe that Eulery may have been treated in Rhode Island, and Julie, correct me if I'm wrong, but was treated in Rhode Island, but then moved to North Carolina. And so when you have a citizen from one state suing a citizen from another state, the defendant is entitled to remove the case from state court to federal court. It's a process which says we have diversity of citizenship. This is not a citizen of my state. And so I want the chance to be able to put this, right, Kevin?
No, that's right. And it's just the venue. So the court is federal court, but the federal court has to apply the substantive law of the state in which the tort occurred. There's a lot of conflict of law issues there that have to be analyzed usually, but the point is it's still kind of a state law cause of action because it's applying state law. Whereas Mitra brought a cause of action based on Americans with Disabilities Act. That is a federal statute. That's subject matter jurisdiction. You can only bring that in federal court. Citizenship of the parties don't matter.
Great, thank you. Okay, let's start queuing up some questions. If you would like to ask a question, first of all, I want to say we're going to stick to this topic, and we can have open discussion and we can have disagreement, but on this topic only. So please have a clear question for our speakers or a brief, meaning brief comment ready to go on this topic. And then we're gonna, if you're veering off, we're gonna thank you and move on. So if you want to be a speaker, there's a little button on the bottom. Then you use the raise hand to request being changed to a speaker, and then we'll switch you. If you are moved to speaker, please, unless you're speaking, use your mute button so that we don't hear your background noise. And also, do not use the voice changer on Twitter. If you do that, we're going to remove you from the stage. Okay. Let's see. Do we have anyone?
We have one request from Mountain Gal.
Okay, great. Yeah, let's hear from
Hey,
her.
yeah, I realize there's several senators that are trying to remove testosterone from the being a controlled substance, but as of right now, it's not. Is there a potential? I find it hard to believe that all these informed consent clinics out there, Planned Parenthood in other words, are following the letter of the law for a controlled substance. And I'm wondering if there's any opportunity there, might have to be the AGs, but any opportunity there to go after them just for not following the basic law. I mean, I think we've got factual information about how these drugs have affected, let's say, East German athletes, etc. But if they're not following the actual letter of the law for a controlled substance prescriptions, might there be something there? Thanks, and I'll listen.
And these poor East German athletes, they get very severely maligned. But you know what? I don't know that I'm expert enough to speak on exactly what the violations would be, per level of controlled, per the different categories of controlled substance and the restrictions that exist on prescribing them. I do know, you said AKA, I think Planned Parenthood is by far, we believe now, the largest provider of gender-affirming care, mainly the puberty blockers, it would seem, and testosterone. And that's not me saying that; that's them saying that. They herald that, right? If you go to the website or watch interviews of, and I don't remember her name, but the current head of Planned Parenthood, at last count, it was over 65 such clinics nationally are administering these, and so they're providing a lot of the care. And I think attorneys general are starting to turn and look at that. There have been conversations about that, and certainly, whether you agree with everything that Florida and Texas has done, they're certainly looking at it. It's a good point.
Do we have anybody else who has questions? I know I received a direct question that was, can you explain the laws against advertising for off-label use? Can the doctors go on TV who say the blockers are effective? Can they do it even though, as long as they don't say a brand name?
No.
Like, can they talk
No,
about
they can't.
blockers?
The law basically is, and again, I'm not. Please, I'm not a. I've never defended. Well, I have defended some mass tort pharmaceutical, but I haven't done it. At a large firm for years and years. I've done some of it, but you can look up the regulations on off-label use and their inability to advertise. If you Google it, I don't know if you give you the right answer. If you Google it, but they're not allowed to promote. So pharmaceutical companies are not allowed to promote the product. They're not allowed to advertise it. That's not the verb used. It's promote. So they're really not supposed to push it at all, right? Whether it's for that type of care, of course, you can't call it an illness. You got to straddle the fence in order to get insurance coverage for it. So of course they play both sides of the fence on it. But for that type of DSM diagnosis, they are not allowed to promote it in any way, shape, or form. And that's why we think that whistleblowers, everybody on this, all the hosts think that whistleblowers and people coming from these clinics that come out and say, look, they're definitely promoting it, if that's what's occurring, we'll see. And getting discovery into the documents and emails and files is going to be very important. And I think attorneys general are going to eventually play a large role in this, as are these existing lawsuits. That's why I'm saying these initial lawsuits are really paving the road, because there's going to be discovery where they can seek discovery from these hospital systems, right? Provide detail with particularity all communications you've had with any pharmaceutical company regarding the use of puberty blockers. They're going to fight over that for 2 years before they give you the production. And hopefully there will be some, hopefully is the right word, but obviously it could be some interesting things that turn up there.
So
Okay,
I could add some comment to that. Physicians can prescribe off-label medication as long as they are not negligent in prescribing it. Okay, so there's no rule that prevents them from doing so, but they still have a duty not to be negligent. So they still need to monitor and make sure that it was done for a correct purpose, for a health purpose, and that the patient is making progress as expected. With respect to off-label marketing, that's another matter, and that affects the pharmaceutical companies. And off-label marketing is prohibited. And it would be helpful to have an insider whistleblower come forward who can share information on how a pharmaceutical company might be promoting or otherwise instructing physicians on the use of either cross-sex hormones or puberty blockers, and sort of the information that they use to present to gender clinics. But barring an insider who holds that information, it is quite challenging to proceed.
Yeah, that's unfortunate, but yeah. Okay, so clearly we need some people to come forward from within the clinics. We're going to take a question from Donna, and then after Donna, we'll go to Alex. Donna, you can go ahead and unmute.
Hi, thank you. I just wanted to ask, I think it was Kevin that was saying, if the doctors come up and say, well, we were following WPATH's standard of care, but is that just immediately going to get the doctor off of the hook? If I've been following this issue for a while, and what WPATH has to back up in terms of systematic reviews and data to claim that these treatments, whatever, are ethical and effective is almost nothing. Is it not the doctor's responsibility to make sure that what they're doing is effective treatment? Or are they just off the hook because they say, I follow the standard of care? I'm just thinking about in the opioid crisis, they literally had sales reps going in and looking the doctors in the face and saying, it's not addictive. And the doctors were just saying, okay. And I'm thinking, you had a medical degree, but a sales rep just told you it was okay, so you did it. So I guess my question is doesn't this lie on the doctors who've been in medical school to recognize, like, hey, something's really wrong here?
Well,
I guess.
I want you on my jury, but yes, I mean, I agree 100% that's what should occur, right? That you can't just take WPATH, I don't want to say at its word, but you can't take the WPATH standard and not look behind it, especially when it doesn't take much to figure out that there's nothing behind it, right? It's an emperor with no clothes. But the way, I think your question is the way it plays out, right? So any of the lawyers on this call can speak to this, but each side hires an expert. Each side hires a couple of doctors, basically, who practice in this area and work for big, have a lot of credentials. And the doctors come in, and one doctor for the defense says, I've reviewed all the standards. I'm not saying it's just WPATH. I've reviewed all the standards of care, and I'm familiar with the standard of care practice in this industry because I've worked in it for 30 years, and I've been on hospital boards, and I'm familiar with the standards of the different organizations without listing them again, and the AMA, and they all were okay with this standard of care of administering T at this point or administering puberty blockers after 2 visits or whatever it is. And then the plaintiffs come in with their person and says there are a couple of doctors and say, no, that's wrong. They had a duty to do more than that. They had a duty to look behind WPATH. And by the way, it doesn't meet the standard of care just to blindly follow, an organization who puts out standards that has disclaimers. For example, most of the professional organizations have disclaimers that say you can't use these for standards of care. Well, why are they commonly called standards of care? So they want it both ways. So it's really going to be an evidentiary issue between the experts. Hopefully, what we're hoping on let's say the victim's side here, is that these lawsuits are not thrown out on dispositive motions or summary judgment based on the judge's ruling that the evidence is so strong that this was the standard of care that no reasonable juror, that's the standard, no reasonable juror could have found otherwise, right? And they can basically dismiss the case before it gets to a jury that way. So what we're hoping for is to get to a jury, right? Let's let a jury decide this. Let's let a jury hear all the evidence, including everything that you pointed out. What will they think when they hear what the evidence is behind this stuff, right? And how politically active these members are that are promulgating these quote unquote standards. So I would also say, going back to the beginning, that these lawsuits aren't cookie cutter in that sense, that many of them say, even if you followed, I know I've made this point a couple of times, but I probably buried it, even if you followed WPATH, or even if you followed the Endocrinologist Society's recommendations, they fell short because they didn't consider that this kid had all these other comorbidities and they didn't treat them first, right? Because you would have that lawsuit regardless. Let's leave out trans care and gender care. Let's say you went in because you had a sore shoulder, right? And the doctor has a duty to take a full differential diagnosis, consider all the less aggressive ways to treat it before they, cut in there and try to fix the tendon. You go to PT first, right? And so even if we weren't talking about this realm of surgery, of radicalized care, the doctors would still need to do that, to take a full differential diagnosis, do the most conservative care and treatment first. And they're not doing that. They're not doing that. So my answer to you is, I think, and I feel very strongly, and I know everybody on this call does, at least the hosts do, rather. Sorry, I can't speak for everybody on the call, but the hosts feel very strongly that it doesn't come close. They don't come close to following the standard of care. This is such a radical treatment. Cutting off healthy body parts it's never been done. I mean,
Right.
in the history of the world, it hasn't been done. So you've got to think that you would be a little more diligent if you were a medical professional whose logo in Latin says "Do no harm."
Yeah, and
I don't think that's actually what it says, but that's what people think it says. So good enough.
So I wanted to just,
Uh,
and I could, if I'm straying a little bit, I'm sorry, but just real quick, if it's my understanding that all of these medical associations go back to WPATH, the Endocrine Society, all of them, and somebody here maybe correct me, and if it's off topic from the legal, that's okay too. But it seems like WPATH is who they are citing as being where they got their standards from. I don't
Well, I don't
know.
know, Mitra. You don't agree with that, do you? I mean, the American Psychiatric Association, that was done by Rafferty, who authored the paper basically by herself, and there's even a disclaimer on it saying that the author takes all responsibility for the content. What, 2019? Am I getting my dates and people wrong there? Somebody
No,
correct me.
Rafferty's who did it. Yeah, I remember that, and I'll keep my
He's
opinion to myself about
right.
that.
Yeah.
It's
Well,
off the rails.
right. So he
2018.
2018, and he has that disclaimer on. I mean, it's crazy. So they couldn't even get a consensus, right, on the standard. Now, I don't think they base on W. I think WPATH is hugely persuasive to them, but they do not cite WPATH as authoritative. I don't think. I think primarily they're citing their own. You know.
Okay, that's what I wanted.
Yeah, I think that's right. They might.
Thank
Okay.
I don't know if they dropped a footnote to it or not. Maybe they did, but I think they're coming at it from different angles.
Um, I want to take some more questions, so I'm going to move along. But maybe we can touch back onto the Endocrine Society's disclaimer for their, um, their standards that they. I mean, I guess they're not standards, but what their advice on this or recommendations, because that's another strange aspect when you have a disclaimer that says, well, don't consider these standards of care. Okay, let's go to Alex. Next, Alex, you can unmute yourself.
Hi there. I'm not entirely sure how much help I will be for you all because I'm from Canada. I was actually transitioned at 16. I'm 24 now. I was actually brought in to the medical side of things from a therapist. So if you want a whistleblower, I'm from Canada, but I don't know if that'll be helpful. But yeah, insider information.
Yeah. I saw your note in the comment, in the comments, and I think any of us would love to talk with you. And I think after the call, we'll let's please the coordinators of the call set up something so we can talk more.
Absolutely, feel free to message me if you need, for sure. Thank you.
That sounds very helpful, and I know you feel very strongly about it. It's personal to you, obviously, given what you've been through. So I'd love to talk to you. Here's the disclaimer. The Endocrine Society makes no warranty, express or implied, regarding the guidelines, and specifically excludes any warranties of merchantability and fitness for a particular purpose. The Society shall not be liable for direct, indirect, special, incidental, or consequential damages related to the use of information contained herein. Now, unquote. How in the world can a doctor use that to help establish a standard of care with that disclaimer? It's crazy.
It's crazy. We're going to call in Julie next.
Hey, I've never actually done a space. But I come about this, just a disclaimer, I am not an attorney. I come about this from what you would consider to be the other side, quote unquote, a TRA, who covers these detransitioner cases, just to provide information to the entire community about what is occurring. And I appreciate that you saw the information that I provided and, corrected. So my purpose here is just to give a little bit of reality and context, because I think there have been a couple misinterpretations here, and just wanted to make sure that everybody is informed accurately. The two cases that are in federal court, July Carlin and Hannah Ullery, the Hannah Ullery case actually was removed to federal court, and most of the plaintiffs, except for, I believe, Michelle Forcier and Julie Lyons, were replaced with the United States Attorney's Office, which is kind of sort of exactly what's going on in the July Carlin case, which I know, Mitra, you're on the call, so I don't expect you to give opinions, but I know that that case is currently on a stay because the U.S. Attorney's Office is trying to figure out if they're going to replace the defendant in that case. But also, the Ullery case is on a stay by itself because the United States did try to dismiss it based on Federal Torts Claim Act because Hannah Ullery did not go through the filing process, the administrative filing process, accurate for based on HHS, and so she's going through a 6-month stay to go through that process before they determine if it's going to continue. As for other cases, I know people mentioned Kaiser. There are 3 cases that I'm familiar with Kaiser. 2 of them, Richard Anumene, I apologize if I'm saying that incorrectly, and Kayla Lovedahl, otherwise known as Layla Jane. Those 2 cases have actually been compelled to Kaiser's binding arbitration. And I find it really interesting, too, that Layla Jane, Kayla Lovedahl, basically went completely AWOL ever since that ruling occurred, so I'm a little worried about her. The other case for Kaiser is Chloe Cole, which actually today we got breaking news, which I don't want to say anything because it's still a tentative ruling in what I'm seeing. The hearing is tomorrow. That her attorneys did actually get the motion to compel arbitration denied. So that is possibly going to move forward. I want to say also Soren El Daco is another one that has really moved forward. 2 defendants have already had the case dismissed against them. And I will say that Soren El Daco's case in Texas is probably the only one that I've really said personally, in my opinion, has a case against her physicians, her surgeons, specifically because she details actual negligence in the aftercare and not necessarily based on regret. The other thing that I want to say straight is that the WPATH files has been mentioned a lot here. First of all, it's SOC 8 that is the current standards of care. But the other thing is that the WPATH files, I don't think they're going to make a lot of difference in these cases. Number one, because of the authors of the study, not study, it's a report. I've done quite a bit of extensive reporting myself on Mia Hughes' own words. And even though the WPATH files FAQ does state that it wants to improve care and not remove it, Mia Hughes' words say something completely different. She has stated that she wants the gender dysphoria diagnosis to disappear, as well as she wants to remove care from as many people as possible. I believe her words were dissuade people from receiving care. As for these cases ending up in a whatchamacallit, mass lawsuit. Sorry, my words here. I know that they tried to do that in the UK. They tried to do a class
Um,
action. Oh, go ahead. No, I'm just here
yeah,
to give
sorry.
information and have a conversation. So stop me
Yeah,
whenever.
yeah. I appreciate it, and I think you know we'll get a response. But do you have a question?
No, I was just making a comment
Oh,
and
okay,
trying to have a conversation
got it.
and make sure that everybody was actually informed about the state of these cases and where they're actually going, rather than, ideology on either side.
Yeah,
Okay,
this is
great.
Kevin. I'm not. I listen. I appreciate the update on them. We were careful not to try to go through every who shot who that's happened on the cases. That's why we just did a run through at the beginning of the general theories and what states they're pending in. I encourage anybody to go to their websites and look at them and look at the briefings, and look at the filings and figure out exactly where each one is. And on the motions to compel arbitration, that's just one of the many complexities that I raised. It's going to happen in a lot of these cases. You may be aware that the different administrations, including Theo Biden and the Biden administration, removed the ability to compel arbitration on many of the med mal causes of action. And then it was flipped back, and then it was flipped again the other way. So there are windows and very complicated appellate issues on a lot of those. So we'll see how it all plays out, right, in the long term on each of the cases. But as we said, I listen. I expect a large number of these initial cases or may well lose, right? I think they're going to forge new paths. These cases that are filed now are not going to turn into mass tort litigation. These are individual medical malpractice lawsuits. Mass tort is a whole different thing, right? That's going to be a class action that's going to would develop down the road.
So
But
can I make
certainly, yeah, go
a
ahead.
quick comment on class action lawsuits? There was a UK firm, Pogust Goodhead, that tried to do a class action lawsuit.
Against Tavistock, yes,
Yes,
yeah.
and they couldn't find any plaintiffs. So I honestly think just a reality check is I don't think
And
today
what?
or even 5 years from
Right.
now there's going to be the plaintiffs for a class action lawsuit. And the moment these cases, in my opinion, they're losing cases from the beginning. Once the bill starts coming due from the plaintiffs, it's really going to dissuade others from, joining these lawsuits. And I feel bad for these detransitioners who are being pushed into these lawsuits when they're already so fragile, as it is. So that's just my personal opinion, and that's
Okay.
what I wanted to,
No, I got you.
give my
Yeah, we
two
got it.
cents in.
We got it. Well, we'll see how it.
Oh,
We'll listen. We'll certainly see how it plays out. I think you're severely underestimating the numbers, but we're allowed to have a difference of opinions on it. So
okay, great. Next, let's see, we're going to go to Emmy, then Jules.
Hi, good evening. About a week and a half ago, I guess, when the WPATH files first came out, there was a space, I think it was actually hosted by Michael Schellenberger, but among the different speakers, there was a woman who was a doctor, one of the guest speakers, and I'm sorry, I can't recall her name right now, but she mentioned in passing, because of course they were making comparisons to the opioid crisis, et cetera, and she mentioned that part of the problem that doctors have is that their patients get these surveys about how the doctor performed, et cetera, and if the doctor was pleasant, helpful, et cetera, and so on. And if they get a lot of negative surveys, it affects their bonuses. And I'm sorry, color me innocent, but I mean, I almost drove off the road listening to this because I mean, I just assumed doctors got like a salary from whatever hospital or whatever, clinics they work out of. It never occurred to me that there were bonus incentives in there as well. So I'm just wondering for our two guest speakers tonight, do you know, are there similar incentives in place for doctors who are dealing with children reporting, gender confusion, gender issues, et cetera, et cetera? Because I mean, on any ethical level, I just find it really, really concerning. I mean, they're not trading stock, down on Wall Street. I mean, these are medical caregivers, but especially when it comes to this issue where it just looks like there's been so much wrong done. And yeah, I'm just curious about that. If you know from your experience thus far, thank you.
so is the question specifically if there's a bonuses tied into the physicians surgeons reviews? I believe is that.
Yes, that's pretty
Yeah,
much it.
yeah,
Specifically regarding like gender clinics or hospitals.
yeah. I don't see that as a large piece of this. Most professionals make money based on formulas of what they bring in, right, or pre-negotiated salaries. There may be a small part of their compensation packages that is based on patient satisfaction or reviews, but I wouldn't imagine it's a large part of it. Now, what you could have down the road, I mean, if the last caller is correct, and even though we've had an explosion in gender surgeries, 30-fold increase since 2012, and if the last caller is correct, and this is all legitimate and is not a trend that should be stopped, then there's not going to be a lot of disgruntled detransitioners down the road, right? That all these people, 30-fold increase, first time in the history of the world, just a coincidence. But if I'm right and the hosts on the call are right, then what's going to happen is there'll be complaints to the medical board about unnecessary medical care, about cutting off a 12-year-old girl's breasts. And if that doesn't offend some people, then it doesn't. But I think that some medical boards will view that in an adverse fashion, and that doctors can lose their medical licenses or be cautioned over it eventually. Once the zeitgeist stops that this is being kind and loving by doing this type of aggressive surgery to kids. Okay.
Okay, let's go to Jules next.
Okay, hi, I'm Jules. Can everyone hear me? Okay.
Yep.
Sorry, I've never spoken in a space before. I'm a D-sister from 2010, and my husband is a detransitioner from last year. And I have two things. The first is going to sound kind of more like a brief point, and the second is the question. But first of all, I do think an interesting way to think about this is to expand the idea from detransitioners to anyone who's had gender-related healthcare that they're like not happy with, that they view as like negligent, or that their consent was not fully informed. So people who are still identifying as trans, and it's like I think a like very concrete fact that trans people like are not like some monolithic hive mind, and there are plenty of people who don't kind of like agree with like the main message that some people in this space may have come across. So there are plenty of people out there who, you know, are independent thinkers, and if they've received, you know, poor medical care, may be interested in, you know, pursuing their own, you know, standing up for themselves in their own way. So I think it would be interesting to expand the messaging to include reaching out to people who continue to identify as transgender, but don't think they received proper medical care or proper informed consent. And anyone who wants to comment on that is fine. But my main question was going to be, for anyone who has received the medical care but isn't really on the page where they feel they like want to like bring a lawsuit or do any legal action, or like go public or speak up or anything, because you know it's a whole complex thing to go through. After receiving medical care, you're going to go through several stages. You're going to, you know, go through months of life before you've kind of got your mind set on how you feel about it, maybe. So like for those types of people, is there anything they should be encouraged to do specifically, like in a timely manner, or in like a like strong, confident, forceful manner, like requesting medical records? Is there any sort of timeline on that, or manner in which they need to do it, or anything else that they should be encouraged to do, like before they've even decided that they're even interested in any sort of legal action?
I
Yeah.
would recommend getting all of your medical records as soon as possible. Okay? Before you even consult an attorney, get all of your medical records.
And
Yeah.
one of the issues is the statute of limitations that you need to be very careful of. That even if I think your comment's very good, and I can tell you that, for example, I know Mitra and I have spoken to one person that is not desisting or detransitioning, but has received, you know, it got a poor medical outcome, which I think is your point. It's a straight medical malpractice case, right? It just happened to involve trans care. So yeah, that is also a viable type of lawsuit that we would all look at, just the same way anybody can have bad medical care. But the one danger of letting things go, and I agree, is get your medical records right away. You have the absolute right to them. And hospitals are weird about that. They're like, oh, well, you know, you've got to submit this and that, or we'll get it. No, no, no. You own your medical records, right? Under the ACA, you own your medical records. So you can get all the medical records you want. You need to be careful of the statute of limitations. And as the gentleman a few callers ago who disagrees with some of us, you know, spoke up and updated us on the Tort Claims Act. If you're suing a federal hospital, a government hospital, there are additional hoops you've got to jump through that don't speak to the merits of the case at all. In other words, because a case is dismissed because it did not comply with the statutory requirements of claims notification, which is usually, I think it's 6 months for a lot of things under the, I'm not an expert, on the Federal Torts Claim Act, you lose your call. Even if the guy, you know, butchered you, did everything wrong, you've lost your cause of action. So you need to be careful with time periods, statutes of repose, statute of limitations. And if you think something has gone on, it's safer to go ahead and talk to a lawyer, right? So you don't lose your cause of action or your right of action procedurally.
Great. Good question. Great response. We have two more people who asked to speak, but they haven't raised their hands. Do either, I can't read the whole name, but Ban from Canada, do you have a question? And Leslie Sudek, do you have a question? If so, raise your hands and we'll move you up.
This is me. My real name is Lita, so I can
Okay.
function with
Go ahead.
mine.
Great.
So I just wanted to speak to the whole issue of the physician quote unquote bonus. I'll try to keep this short. It is convoluted, but this is literally my area of expertise before I gave up corporate life and went back to my life as a floor nurse, which is much more satisfying. Fee for service, particularly for primary care providers, is decreasing every year, and they are replacing it with something called alternative payment models. This is also referred to as risk adjustment or value-based care. This is becoming an increasingly important income source for doctors because their salaries have gone down for several years, if you can possibly believe that. And my last job, I managed like $60 million in Medicare payments. The biggest one is called the Medicare Shared Savings Program. But Blue Cross Blue Shield has the patient-centered medical home, and there's more and more ACOs every year. This happened during the Affordable Care Act. So what this means is that they're trying to pay for prevention. But like with everything in healthcare, it is an extremely convoluted system that they use. I promise you, the risk adjustment for people with gender dysphoria is going to be off the charts. It is going to be a mammoth number. I can explain to you how these weighted assessments are done through medical records, but it is coming. It will happen. There's too much money on the line for it not to. So I would strongly suggest to all of the legal minds in the room, do not overlook this. Because if you can attach to this level of income, it is literally billions of dollars a quarter. And if doctors are going to have this incredibly important revenue source interfered with, this is something that's going to happen outside of liability. It's going to happen outside of insurance fee-for-service reimbursements. This is a third rail that, because it's relatively new, most people don't understand and they don't know about it. I have a very odd skill set, and I sort of stumbled into it, and then everything sort of exploded during COVID, which is how I ended up here. But everyone, I talked to a psychiatrist today at work who referred to this as a bonus, and I had to sit down and explain to her what it actually meant. So this is, like I said, this is a very, very niche thing, but it's very, very real. If anyone is interested, I can at least tell you what phrases to Google to get you started.
I would love to hear that. Can you send it to us somehow?
I will start putting something together. If somebody wants to DM me a real email address, I can email you a packet.
Hey, band, Lita, this is Ellen Danick, the co-host. I'll DM you. If you don't follow me already, will you follow me so you can see my DM?
Sure thing. And I'm sorry, what was your name one more time?
I'm Ellen Danick. My handle is EDAEHNICK.
Okay, great. Thank you.
Nice to meet you. Thanks.
You too.
Okay, did we have anybody else who was interested in asking a question? We are pretty much at the 7 o'clock mark. So unless there's anybody else, we're going to thank our speakers. And again, I want to remind people that the next space event for DIAG will be on, it's on April 15th. And it's a discussion of the various laws in the U.S. that promote gender ideology. So that's parental coercion laws, laws that remove children from non-affirming homes and place them in foster families or in state-run facilities, laws that have allowed men in women's prisons, spaces, and sports, sanctuary state laws, those kinds of laws, both passed and on the books. And we've got an incredible lineup of speakers. We've got Kara Dansky, Aaron Friday, Sharon Byrne from Wolf, the executive director from Wolf, Amy Souza, the author of the Bad Facts Substack, who goes by the pseudonym of Unyielding Bicyclists and is also a DIAG team member. So I hope you'll join us for that. We'll be promoting that soon. So be on the lookout. That should be another great space in our legal and legislative series. So thank you all for joining us. It's been fascinating for us. Hope you've enjoyed it. And please check out our website and join us at di-ag.org. Thanks and good night.
Thank you, DIAG. Thank you.
Good night all.
Good night.